next let's discuss what the power of what the corporation can do. And the answer basically is that a corporation can do pretty much anything that a person can do. A corporation is a legal person. And the express powers of a corporation can be found or can be implied from. I mean, this is a little bit of a misnomer. You don't really have a clause, in U.S. Constitution saying what corporations can do, but there are implication and freedoms that apply to corporations. For example, in a major U.S. Supreme Court decision a few years ago, the U.S. Supreme Court said that a corporation has freedom of speech. That was the famous Citizens United versus the Federal Election Commission ruling. And you have various state and federal rules that discuss what a corporation can do, but also it's governed by its own governing documents, including the Articles of Incorporation, its own bylaws, and resolutions that are taken by the Board of Directors. What can a corporation do? Well, again, pretty much anything. Purchase, own, lease, sell real property, make contracts for personal property, incur liabilities, issue bonds, notes, promissory notes, things like that, invest funds, sue and be sued, and in general, pretty much whatever a legal person can do. A corporation can also do things beyond what is specifically laid out in the bylaws or in the Articles of Incorporation if those are necessary to allow it to do its normal business. So, for example, a corporation, even if the bylaws don't say that the corporation is allowed to open a bank account, a corporation is inherently considered able to open a bank account because that may be necessary for it to carry out its business. Also, to reimburse its employees for expenses. These are things that, even if they're not specifically laid out in the bylaws, the implication is that corporations are allowed to do these basic things. The question really is what happens if a corporation does something that it's not authorized to do. If the bylaws specifically say, or if the Articles of Incorporation specifically says that this corporation is only allowed to operate a restaurant, and instead of operating a restaurant, it goes out and operates a farm, well, that is considered an ultra vires act. An ultra vires act is something that is beyond the authority of a company to do, an act by a corporation that is beyond its express or implied powers. Remedies, there are several remedies. In other words, one of the corporate shareholders can sue. They can sue for an injunction. They can sue the officers or directors who caused the act for damages. In other words, they can, if the company lost money because of an ultra vires act, that the directors did something that was beyond the scope of the corporation's authority, and because of that the shareholders lost money, they can successfully sue for those things. And they can also bring an action to enjoin the act. Enjoin means to stop the act, to get an injunction against the act, or if it's flagrant enough, even to dissolve the corporation. Okay, so the next issue is how does a corporation dissolve? In other words, how does a corporation actually end? It could be done by a judge. There could be administrative dissolution. We'll see what that is in a minute, or even voluntary dissolution when the company simply decides to stop operating. Voluntary is the easiest one to discuss because voluntary dissolution simply means that the shareholders vote to end the company. If the company hasn't actually commenced any business, well, then you could simply dissolve it by a majority vote of the incorporators or the board. If there already is business that has been started by the company, well, then, just like some of the other major changes that we saw before, board of directors has to recommend that the company dissolve, and a majority of the shareholders have to actually vote to dissolve the company. It's a fundamental change, and therefore it's something that the board of directors cannot do by themselves. And then you have to file articles of dissolution with the Secretary of State in order to tell the state that you're winding up the business. Then there is administrative dissolution, wherein the Secretary of State, in other words, the state, says this corporation is not following the formalities of a corporation, and therefore we no longer consider it an independent person for legal purposes. Failing to file an annual report, failing to maintain a registered agent, which many states require, as we discussed before, failing to file a change of a registered agent, not paying a fee, they're usually not going to do this right away. Usually they'll send a warning letter to the company saying, you haven't paid your fee, or you don't have a registered agent, or whatever it is, and give them some time to fix it. But in other words, if a company does not, the whole idea of establishing a corporation as an independent legal person is a privilege in terms of it's something that makes it easier to do business and makes limited liability. So based on that, the state can say, listen, if you refuse to follow the formalities, if you refuse to follow the rules regarding the operation of a company, well, then the state can say, we're not recognizing you anymore as this independent legal entity. And again, then in that case, rather than the company issuing a certificate of dissolution, the Secretary of State would do so. Then you could have this. Then you could have judicial dissolution, where the courts can order a company shut down. Sometimes they refer to this as the corporate death penalty. It doesn't happen very often, but if the articles were fraudulent or they exceeded their authority, in other words, some basis in a lawsuit where a court thinks that the only remedy to a particular harm is to dissolve the company. When a company does dissolve, or when a corporation does dissolve, they have to wind up, just like the partnership winding up period that we saw a little bit earlier when we were talking about partnerships and LLCs. Very similar. First thing, the company assets have to be liquidated, and creditors have to be paid off if they're paid. If there are no creditors, or the creditors are already paid, then the shareholders would get the rest of the money, if any. And then the company is terminated. The ending of the corporation is the termination, which occurs only after the winding up of all the corporation's affairs, the liquidation of it, and the distribution of proceeds to anybody who has a claim.